Dear student, welcome you all again in online classes. Now we are going to discuss a very complex issue under the joint family, that is property. You know very that importance of the property. So now we are going to discuss the property under the joint Hindu family. There are two types of the property generally flows under the joint Hindu family. First is known as the uh, joint family property, and other property is known as the separate property. If you see my last video, I have discussed the relationship between the joint family and coparcenary. When we were discussing about the coparcenary, I told you that under the coparcenary property, by birth, a coparceners have a right. So the nature of the property, that is very important to all of us to know. What is the nature of the property? Because once it is proved that a property is a joint family property, then all the co-pastors have equal rights and possession over the joint family property or the co-pastoral property. Second important feature is that by birth a person have acquired the right over the co-pastoral property. That is why it is called unobstructed heritage. Joint family property or co-pastoral property or unobstructed. Unobstructed means without any obstacles. By birth a person acquire his right as a co-partners. But once it is proved that no, it is not a joint family property, it is a separate property, then the person who owns this kind of the property will have a exclusive right over the separate property. So it is very necessary for all of us to know what is the nature of the property, because once it is proved, again I will repeat here that if it is a coparcenary property or joint family property or unobstructed heritage, then by birth a person or all the coparceners have equal right and possession. Once it is proved that no, it is not a separate property, coparcenary property, it is a separate property, the person will have a exclusive right over the separate property. Now we we want to know what is the mode of acquisition of a joint family property. How can we know that property? What is the nature of the property? So for this purpose, here there is a mode of acquisition of a coparcenary property. Here there is a different mode in which a coparcenary property can be earned. So first and foremost important mode is ancestral property. Ancestral means if a person inherited from his ancestors, that is called ancestral property. Here there is a confusion. Who is our ancestors? Suppose that there is a person, his father's side, father, all the other upper generation of the father's side, his mother, father, nana, parnana, and rest of the other upper side, and apart from the father and mother, maternal uncle, paternal uncle. So my question is, all these called all the co-partners maybe, but for the purpose of ancestral property, it is the rule that if a person acquire anything from his father's father and great grandfather, that property will be treated as his ancestral property. Means if I acquire anything from my father or my grandfather or my great grandfather, that property I will inherit as a coparcenary property or joint family property. If I inherited anything, any property apart from these three generations, means if this person has given anything to that person, means if X acquire anything from his great grandfather, then that nature of that property will be treated as his separate property. In other words, if a person acquire anything from his parental side, we cannot say that all the property will be treated as his co-pastoral property. If a person acquire three generations of his parental side, that property will be treated as his ancestral property. Rest of the other property will be treated as his separate property. Likewise, if a person acquire anything from his maternal side, maternal father, maternal grandfather, then property, it was the earlier it was the rule that that property would have also treated as his ancestral property. But Venkat Ramaiah case, the court were made a confusion, and that property court declared that his ancestor property. But later on, the Privy Council had made it clear that Mohammad Qasim Khan case, that property, such kind of property will be treated as his separate property. If a person acquire anything from his maternal side, property will be treated as his separate property. Likewise, if a person acquire anything from apart from the paternal and maternal side, means if a person acquire anything from his paternal uncle or maternal uncle, that property will be treated as his separate property. So it is ancestral property. Now come to the second mode of acquisition of joint family property, that is called property obtained on partition. You know, partition, once joint Hindu family come to an end, that is called partition. Partition means each coparcener now known his own individual share of a joint Hindu family property, that is called partition. So suppose that if on partition, if there is a joint Hindu family, look at this figure, father, his 3 sons, son 1, son 2 and son 3. If there is a partition under this joint Hindu family, then if suppose that there is a 1 lakh rupees as a joint family property, after the partition there are 4 persons, 1, 2, 3, 4, all will get 25,000 each. 25,000 each. Now F will say that this 25,000 is his separate property. Likewise S1 25,000, S2 25,000 and S3 25,000. But if for the S2, S4, after S2 son, S4 and S5 will receive this property as his ancestral property, or because his father has obtained this property on partition. So in respect of his own son, the property will be treated as the joint family property. But in respect of any other person, his property will be treated as his separate property. Likewise, if you see property obtained on receiving gift, you know well that gift is transfer of property by one person to the other person without any consideration. If I have transferred my property to any other person without any consideration, it is a gift. So gift is generally made in connection of love and affection. So if a person if a person gave his property to any other person, he will acquire this property as the separate property. But again the same rule will apply in respect of his own son and their grandson. His property will be treated as his joint family property. So now come the fourth mode of acquisition of a joint family property, that is called property jointly acquired by all the co-partners. It is a general mode of acquisition of a property of a joint family property. Means if all the co-partners will engage any profession and acquire and earn anything, that earning will be treated as his joint family property. Generally, if you see, go to the Aminabad and so many other market, generation after generation people are engaged in one profession, and from the morning till evening they are using their labor for earning the money. That money will be treated as his joint family property. Likewise, if you see the income of hereditary profession, there are certain profession, जैसे मान ले पुरोहित का जो व्यवसाय हो या फिर पुजारी का व्यवसाय है, जहाँ पर एक व्यक्ति अपने स्किल के द्वारा नहीं, अपने इसलिए कि वो किसी पर्टिकुलर परिवार से बिलोंग करता है, उसे वो गद्दी दी गई है और उससे कोई अर्न करता है, जैसे पुजारी को, जैसे मैं कहा, उसने कोई अर्न की है, वो प्रॉपर्टी जो है वो हेरिडिटरी प्रोफेशन के तहत आ गई। हेरिडिटरी प्रोफेशन के तहत ये नहीं होगा कि एक डॉक्टर का बेटा डॉक्टर हो गया तो वो हेरिडिटरी प्रोफेशन, नो, डॉक्टर बनने के लिए MBBS, MS और तमाम क्वालिफिकेशन पास करने पड़ते हैं और MCI में रजिस्ट्रेशन करना पड़ेगा, तब आदमी डॉक्टर बनेगा। तो प्रोफेशन ऑफ डॉक्टर्स एंड एडवोकेट्स विल नॉट कम अंडर दिस कैटेगरी, दैट इज अ डिफरेंट थिंग्स। Now the mode of acquisition of a joint family property is 6, that is property thrown into common stock and blended property. That is very important. Generally, it is happened under the joint Hindu family system that one co-partner who has his own separate property blended with his property to a joint Hindu family property. Now the question is, after the blended, what would be the nature of that property? Suppose that there is an ancestral home and there are two flory ancestral home. One coparcener by using his separate property and build third building, third floor of his ancestral home. The question is that after blended with his separate property into the joint family property, what will be the nature of that property? Answer is, now his separate property will be treated as his joint family property. But here the intention of the person will be the paramount consideration. If I have blended my property with the intention that after the blended it would be treated as joint family property, then property will be treated as his joint family property. Otherwise, it will be treated as his separate property. So intention would be the paramount consideration. Next is property exchange for joint family property. If you sell an ancestral home or instead you are buy a flat, then nature of that flat will be treated as joint family property. And last is accretion. Accretion means that suppose that Karta of joint Hindu family has deposited joint family property into the bank, and after certain years bank will give interest over that property. Now the question is, what would be the nature of that interest? It is Karta separate property or joint family property? Because this equation is meant for that joint deposit of that joint family property. So after that equation, I mean to that interest will also treated as the joint family property. So here it is the equation of different mode of a joint family property. वो ये सारे तरीके हमने आपको बताए हैं जिसके से कि joint family property जो है वो अर्न की जाती है, और बहुत ही जल्दी से हम लोग देखेंगे कि कैसे सेपरेट प्रॉपर्टी अर्न की जाती है. Now the different mode of acquisition of a separate property. So first and foremost mode of acquisition of a separate property, if you see separate property, gain of learning. If a person earn anything by his own skill, labor, that property, the nature of that property will be treated as separate property. There is a lot of confusion over this issue. 1930 से पहले मैं आपको बताऊं कि जैसे घर में कोई व्यक्ति डॉक्टर बना, ज्वाइंट हिंदू फैमिली में एक बच्चा पैदा हुआ, एक लड़का पैदा हुआ, ज्वाइंट हिंदू फैमिली प्रॉपर्टी और ज्वाइंट हिंदू फैमिली के सभी सदस्यों ने उसको पढ़ाया लिखाया, ज्वाइंट हिंदू फैमिली प्रॉपर्टी से वो डॉक्टर बना, बाद में ज्वाइंट हिंदू फैमिली प्रॉपर्टी को वो इस्तेमाल कर वो हॉस्पिटल बनाया, और बाद में अपने स्किल से वो ऑपरेशन करके सर्जन बन के वो पैसा कमाने लगा और लाखों रुपए कमाना शुरू कर दिया. नाउ द क्वेश्चन अराइज एट दैट टाइम, व्हाट वुड बी द नेचर ऑफ दिस प्रॉपर्टी? बिकॉज वी शुड नॉट फॉरगेट इट दैट कि ही became the doctor after using all his joint Hindu family property. All the member of a joint Hindu property have exhausted all his money to become his doctors. Now the question arises कि what the doctor is earning, what would be the nature of that property? तो 1930 से पहले, 1930 से पहले ऐसी प्रॉपर्टी को ज्वाइंट हिंदू फैमिली जनरली माना जाता था, क्योंकि वो ज्वाइंट हिंदू फैमिली जो है उसकी पैसे से ही वो डॉक्टर बना, अतः वो कमाया, अतः वो जो अर्निंग हुई वो ज्वाइंट हिंदू फैमिली की अर्निंग है या उसकी अपनी अर्निंग है. इस पर कभी कभी उसको ज्वाइंट फैमिली की प्रॉपर्टी मानते थे, कभी कभी सेपरेट प्रॉपर्टी. ब्रिटिश शासन काल में एक एक्ट पास हुआ जिसको कहते हैं गेन ऑफ लर्निंग एक्ट. गेन ऑफ लर्निंग एक्ट, इस एक्ट ने गेन ऑफ लर्निंग एक्ट 1930, इस एक्ट ने इस बात को क्लियर कर दिया कि इफ अ पर्सन यूज हिज स्किल, लेबर और एनी काइंड ऑफ द अदर थिंग by using his where he has applied his own mind, that property will be treated as his separate property. Here learning doesn't mean that there is a degree. Learning means using of your skill. एक कॉबलर या एक बार्बर भी लर्निंग पर्सन कहलाता है इस अधिनियम के अंतर्गत, क्योंकि वो अपना स्किल यूज करता है। तो now it is absolutely clear that through the learning, if I have acquired anything, that property will be treated. I am delivering the lecture, instead I am getting salary, that property will be treated as separate party, which I am going to discuss in a second. If a person earn through his salary, remuneration, पारिश्रमिक या वेतन से कुछ भी कमाया जाता है, यानी कि अगर मैंने परिश्रम की, अगर मैंने श्रम किया, पसीना बहाया, इसके एवज में इफ आई अर्न एनीथिंग, दैट प्रॉपर्टी विल बी ट्रीटेड एज separate property, and I will have a exclusive right over this property during my lifetime. No other my relation, including my parents, my wife, my daughters, my son, have any right over that property. Third, government grant. Government is giving generally government is giving the grant, and that grant will be given by to a person by individual in nature. So अगर कोई गवर्नमेंट ग्रांट दे रही है किसी व्यक्ति को, वो इंडिविजुअल कैपेसिटी में देती है, ऐसे ग्रांट को जो है सेपरेट प्रॉपर्टी ट्रीट किया जाता है। उसी तरह से मेंटेनेंस, इफ वाइफ इज गेटिंग मेंटेनेंस by her parents or by her husband or any other relationship, this maintenance will be treated as separate property. Or last is accretion. If any person is using separate property, making double and triple, that the nature of that property will also treated as separate property. So here there are two different modes of acquisition of a property. First known as the joint family property, and other is known as the separate property. Thank you very much.